This current session of administrative law is a revision class in which we are going to take up the definition, evolution, nature, and scope of administrative law. Although this topic has been taught and has been already revised in many a times in the class before your exams also, but today we'll try and look into the summarized version of the topics that we have already covered for the recapitulation purpose. As we have looked into the various definitions given by different authors like Dicey, Ivor Jennings, Ivy Messi, Salmond, Griffith, Jan, C.K. Takwani, I.P. Messi, and when you look at their definition, all of them are focusing on the four major limbs of administrative law. All the definitions they are talking about that the administrative law deals with the composition powers of the organs of administration, how it fixes the limits on the power of these authorities, and it has how administrative law prescribes the procedure that needs to be followed by the authorities and what are the in which manner they must exercise their power, and how administrative law exercises control over these authorities through judicial and other means, and how judicial and everything, all the process which falls under the administrative law, it gets covered by judicial as well as extrajudicial manner, and how all these things cover administrative law, to control them through tribunals and positions like ombudsman and all that we have discussed earlier also in the classes. Like if you for that matter, if you look into the definition of Dicey, he simply defines it that administrative law relates to that portion of national legal system which determines the legal status and liability of all state official, and he defines administrative law as rights and liabilities of private individuals when they deal with the officials, government officials, and administrative law how it specifies the procedures by which these rights and liabilities are to be enforced. And similarly, if you look at definitions given by other authors, they will talk about the four important characteristics, the limbs that we have just discussed in this particular section. So, when we talk about the nature and scope of administrative law, as we have earlier discussed also and have taught you, that it's not a codified law, not written, not precisely defined anywhere like we have law of contract and IPC and all, but rather it's a unwritten, uncodified, judge made law. So it gets developed over the period of time, so it's still evolving, still developing, hence the scope is pretty much wider. So in which I have taught you that how it is limited to law, and it concerns me basically about, it concerns itself with powers, procedures of administrative agencies. And in class I've taught you about Professor Casey Davis' view, Friedman, and Griffith and Street's idea that you can focus on in order to revise the concept. Like when we talk about nature and scope of administrative law, Friedman, he said that the legislative power of administration, both under common law and under statutes, the administrative powers of administration, both that is covered under the common law and under a vast scope of other statutes, and the judicial and quasi-judicial powers of administration, all of them statutory, and the legal liability of public authority, it covers all these factors, and the power of the ordinary court to supervise the administrative authority, all of it gets covered under the scope of administrative law. And if you look at Professor Griffith and Street, they believe that the operation and control of administrative law, it is the primary purpose of administrative law, and it deals with the different kinds of inquiries, like what are the limits of those powers, what sort of powers does the administrator exercises, what are the ways in which administration is kept within these limits, what are the procedures followed by the administrative authority, and what are the remedies that is available to a person which is affected by administration. So if you talk about administration, and if you talk about what kind of heads what kind of nature of power that is being exercised by the administrative authority, you can study them under the following head, like legislative or rule making, judicial or adjudicative, or purely executive. So if you try to look at the that what are the factors or what all gets covered under the ambit of administrative law. So we have powers of powers of administrative authority. It gets covered under it, like purely administrative actions, pure power of lawmaking, rule making. And then we have legislative rule making, quasi judicial, adjudicative organs, bodies, rule making. And the other is the rule making power of administrative agencies and department that I have taught you under delegated legislation. And what are the safeguards which are available against the abuse of administrative power, like that we have discussed under delegated legislation in the form of legislative and judicial control and other and procedural controls. And then we have adjudicative, judicial or quasi judicial functions and powers of administrative bodies. That is, you have one of the examples you have is administrative tribunals. And the procedures of administrative bodies and tribunals, minimum procedural guarantee of compliance, rules of natural justice, liability of government, the control mechanism, remedies which are available against executive arbitrary action, like writ jurisdiction and writ jurisdiction of Supreme Court, High Court, and other remedies which are available under Specific Relief Act that we have discussed in extensive manner in our classes also. Public undertaking, corporation, and government companies, all of them will be covered under the ambit of administrative law. So when we talk about the concept of evolution, or how the what led to the growth and development of administrative law, you have to, as we have done in classes, you have to again revise the comparative analysis. You have to do comparative analysis of the whole thing, that how it all developed, how it developed as a legal, development happened as a subject. It got evolved. So I have taught you that it was during 20th century it was considered as one of the most outstanding legal development that has happened during that time, and how it with the passage of time it evolved, it got matured and grown tremendously in quantity and quality in 20th century in various independent and developing democratic countries. Like we have done a comparative study of France, US, India, UK, and we have seen how this whole concept of administrative law developed there. Like we have discussed in droit administrative of France, how it was a fully developed a system. Administrative law was fully developed law even before the 20th century. When you take up example of France, droit is a very important system that you have to do. And in the 20th century we have given we have also seen that a lot of importance was being given to the other domains also, like socioeconomic domains, and how how administrative authority, their role started growing with the changing nature of the society itself, changing concept of the state brought into into focus their excessive character and excessive importance of the administrators. And so if we look at the main solid reasons what led to the growth of administrative law, we have seen in France with droit administrative. In England we have seen I have taught you that A.V. Dicey, a British jurist, how he earlier in 1885, during that time he rejected this whole concept of administrative law. However, later on we have find that until 20th century there in England, administrative was not accepted as a separate branch of law. And then I have taught you about Lord Donoughmore Committee in of 1929, and what were the recommendation, and how administrative tribunals and inquiries act was passed, and how finally, in England, administrative law was evolved and is still developing. And in United States, we have seen that administrative law, its existence and its growth was ignored until it grew up to become the fourth major branch of the state. And then how various legal scholars like Frank Goodnow, Unstrud, and Ernest Fruin had already authored many books on, a few books on administrative law. And it was in 1933 that a special committee was appointed to determine how judicial control over administrative agencies could be exercised, and 46 weeks with the Administrative Procedure Act was passed, and which provided for judicial control over administrative actions. And when we talk about India, administrative law, if we see it was not a new concept. We have seen in Mauryans, Gupta in ancient India had a centralized administrative system. And it was with the coming of British and administrative law in India that we went through changes. Like after independence, India adopted a welfare state and henceforth increased the state activity. So when you're talking about the changing nature of the state, you have to trace, as I have taught you, four stages that changed the state, changed its character. So when the with the the state India, when India became a welfare state, it increased state activities, and these state activities and powers of the government and administrative authority increased, so that the need of the rule of law and judicial review of the state action. And if rules and regulations were passed by the administrative authority, it were found to be beyond the authority's legislative power, and hence it was considered that such orders, rules, and regulations were to be declared ultra vires or unconstitutional, illegal or void, and hence have to go through the judicial scrutiny. So the basic reason for the growth, primary reason for the growth of administrative law in countries who are welfare states is similar, is because of the changing nature of the state. As you have taught you, the character of the state from laissez-faire to maternalistic character. And then finally welfare state led to the increase in the role of the state itself, and further delegated and increased the functioning and the power of the administrators also. And the growing inadequacy of legislature also played a very crucial role. We have found that the your legislative system being involved in so many different activities, which leaves them with no technically no time to deal with every day issues, and even with to look into the detailed provisions, which led to again it was felt necessary for them to delegate some of its power to administrative authority. Then the judicial system, which is already or always has been overburdened. We have seen that it was not in a position to dispose of speedy in a speedy fashion matters which involved employee and employer, matters related to strikes, lockout, matters related to it was considered as very technical and expensive, and it required a speedy solution. And the radical change of philosophy also regarding the role played by the state, which happened, like state has moved from its negative and minimalistic traditional policy of maintaining law and order to being a welfare state, has further increased the duty of the state, and made them overburdened, and further they had to delegate their responsibility to administrators also. So the further heavy burden on the executive also was one of the reason. And as a newly found administrative law, it also provides for the scope in the experiment in the administrative process. Here we have discussed that how administrative authorities now, because of their newfound power and responsibility, have been given greater flexibility and greater power in terms of their discretionary power. Administrative authority now could take immediate preventive measures, like licensing, rate fixing, and opposed to regular courts, and had to where we had to wait for where the parties had to wait for a long duration of time before getting the order issued to them. And administrative authority could take effective steps for enforcement of preventive measures like suspension, revocation, cancellation of license, and which were generally not available through regular courts of law. So when we look at the evolution of administrative law, and we look at particularly in India, so we understand that in modern India, the existence of administrative law can be, not only traced from early Britishers rule, but also we find them in ancient times and rule of dharma, which included principle of natural justice, fair play, and all of it. And till the end of the British rule, however, the government was concerned most primarily with, with the duties only, like collection of revenue, maintenance of law and order. And with changing time, when the government became, when India has adopted the characteristic of a modern welfare state, then with the changing character and the role of the government, we have seen the immense growth and in the powers and responsibilities of the not only the state but also the administrators. And the philosophy of welfare state, it was made the essence of Indian constitution, and provisions were made to secure all citizens socio-economic and political justice, their equality of status and opportunity. And in order to secure these welfare and socialist aims and object, constitution has provided an equipped and exhaustive functional government and administrative mechanism. And when we look at the important aspects of administrative law like delegated legislation, judicial review, government liability, tribunals, and has been incorporated in our constitution already. And the constitution also provides for some administrative agencies to regulate a particular field and different issues like finance commission, interstate council is there, public service commission is there. So all of it is example of how, administrative law was there, got evolved eventually, and how its growth happened in India.